Yeah,
What time do you start?
3:30. That's okay. Okay. Where did I bring her here from? Dade County?
Gadsden. Gadsden.
Oh, Gadsden?
Her
Wha-
EOS date is December 20th.
Oh, okay. Who's going to be working tonight?
From my office, I believe it's Ms. Madison.
Uh-huh. Oh,
I can reach out to them also, though, and just let them know that she's in custody, she's in detention now.
huh. Uh, we're 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 moving in that direction. We're moving in that direction. I just have tonight. I think Judge Porth has tomorrow night. Patrice, do you know how to use this phone?
I do.
Why don't you come on over here? Do you mind? I've got a couple of Spanish ones tonight, and I'm going to have to bring in the. Yeah, that's the thing that's got me.
How to do it, and we're gonna test it with the attorney right now, so you can see how it works. They're gonna see that we think. So what you would do is.
First, how do I get an attorney on the phone?
Okay.
Do I ever have to touch this? Or
You
just
don't
leave that
have
alone?
to, you would just put it on speaker. All the judges have been using just the speaker.
Is that what that is?
Yes, sir.
So I hit this.
Yes, sir.
Okay. Then I just dial the number.
Correct. Now turn it off. And hit the button.
What'd you hit?
The three, that button where the three, that's how you're gonna conference in the other person.
That's if I need to have more than just the person I'm calling on the phone.
Correct, so you just said you had to call the Spanish interpreter.
Right.
So you would, let's say we would call an attorney, for example. So
Yeah,
you
let's
call
turn that
it-
down. Gee, who was in here last? Oh, that
Well,
was
you
Usam.
have to turn it up though.
So everyone
when
can hear.
They start speaking, right?
I got
So
that.
here we are, I'm gonna call the attorney. So you would call the attorney and he would answer, just pick it up. Don't hang up though, not you, Eric, don't hang up.
I call the
And
interpreter.
then you call the interpreter, so now we're calling the interpreter. So that's the interpreter over there.
I see.
And that's them.
Then he
Please just
picks
pick
up.
it up, and then after he picks up, then you're gonna hit conference. And when you hit conference, you're gonna have
Trace,
the attorney
Trace.
and the interpreter.
It's not happening.
It will.
That's not happening. That's so not happening. No, I'm just trying to be very honest with you.
Y'all can hang up, hang up.
That's just so not
You
happening.
can hang
So,
up. He's
so
gonna get it, I
no,
promise.
no, no. But I only have.
Hang up. You
I've,
can
I've
both
only.
hang up for right
I've
now.
only got 3.
That
I've
would
got a
need-
docket of about 70. I've got 3 that
That
need a
would need the
Spanish.
interpreter.
Right.
Okay,
So
we'd
you know what I'm
only
gonna
that
do?
3 times.
Yeah, yeah. So I should be able to do
As a matter of fact,
that. The rest of them, I just have to call the attorney.
okay, why are we on right there? I'm sorry.
No, that's okay.
Morning, everyone. I'm Judge Corey Amanda Coffin, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record today, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are also able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present representatives from confinement status, pretrial supervision, and the clerk of courts, as well as attorneys from the state attorney's office. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but understand that it's dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at First Appearances. After today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, I have two cases that have been requested by the jails to be called out of turn, so I will address those first, and then we have one sign-in that I'll address afterward. The first case on our list for this morning is Douglas Johns on page 8. Who is at North Broward?
North Broward.
Thank you.
Of course, understand.
Good morning, Mr. Johns. Mr. Johns, you're before the court this morning on a misdemeanor capias. This is related to a charge for trespassing. I find probable cause. And Mr. Linder, I'll hear from the state first on this.
Your Honor, I'm gonna ask that this matter be reset for the PM. This case is assigned to Judge Linderman's Mental Health Division.
Okay.
AM, please. Don't listen to him. He knows nothing.
Mr. Johns, one moment, please.
Take your time.
All right. This case has already been assigned to Judge Lerner.
Sorry,
No,
it's Division MI.
Okay. All right. So since Judge Lerner,
She doesn't want it. She's
Mr.
busy.
Johns, please.
I know her very well.
So do I.
I bet you I know her better.
Mr. Johns, Judge Lerner will be here this afternoon for the 1 o'clock docket, so I'm going to reset this hearing to 1 o'clock since she's your
got a
division
point.
judge, and she will be able to determine how she would like to handle this case. Thank you. Okay. Will you hold this for Judge Lerner, please? Thank you. Next will be Dennis Jones on page 10, who is at Conti. Thank you. All right. Good morning, Mr. Jones.
Hello, how are you?
I'm well, thank you. Mr. Jones, you're before the court this morning on 4 ad charges. Count 9 is for first-degree grand theft. Count 10 is fraud, use, or ID of another without consent, $100,000 or more. Count 11 is fraud, money laundering, transferring $100,000 or more. And count 12 is for obtaining property over $50,000 by fraud. I find probable cause for these charges, and I will hear recommendations from the parties beginning with the state.
Your Honor,
Yes.
he's being held on numerous other charges like offenses.
Yes.
At least one of the cases was on an arrest warrant where the bond for the same charge as number 11 was $25,000.
Okay.
So I'm gonna ask that be imposed. Additionally, Your Honor, on his arrest warrant, there were special conditions that were issued. Your Honor ordered that those remain. I would ask that all special conditions that have previously been ordered remain on this matter. It's nebia, collateral, that type of stuff that are relevant to these type of charges.
Right, Mr. Miller, I'll go to you.
Actually, Judge, I
Oh,
spoke
Mr.
to him
Farber, go
because
ahead.
he's no problem. Judge, when I spoke to him, he did indicate he can't afford the bond that's currently set, so we would just ask the court to set bonds in this case as minimal as possible. He's already looking at, I think it's $130,000. He can't afford that as it is, so we just ask the court to set minimal bonds as it can.
Okay. I appreciate the argument. Based on the circumstances, it appears that this may be better suited for a more appropriate bond hearing with the division judge to consider some additional information in light of the other pending charges and bonds that Mr. Jones already has. So for today's purposes, on count 11, I will set the bond at $25,000. I'll leave the other standard bonds in place. And I am going to order that any special conditions of bond that were already in place will remain with respect to these 4 additional charges as well. And once again, as I said, if there needs to be a modification, then his division judge will be able to address that. All right. Good luck to you, Mr. Jones.
All right, thank you.
And then I have one sign-in that we'll be addressing on page 6, Mark Baker. He has a family member present. We'll bring her into the courtroom. Is Mr. Baker at the main jail?
Yes.
Okay.
Just a minute, Your Honor.
Thanks, Deputy, no problem. They're gonna bring him up in just a minute, Ms. Baker. Just hang on one second.
So sorry, I can't hear you.
They're gonna bring him up in just a minute. Just stay right there at the podium.
Okay.
All right, good morning, Mr. Baker. All right, Mr. Baker, you're before the court this morning on one charge of child abuse without great bodily harm. I do find probable cause. At this time, I'm going to hear recommendations from the parties. We'll begin with the state.
Yes, Your Honor. Requesting a $1,500 bond and no victim contact.
All right, let me go to the defense.
Judge, I don't know that he has any prior record. What I would tell the court is he's lived here for 34 years. He's married. He has 2 children, aged 24 and 15. The 24-year-old doesn't live there anymore. The 15-year-old does. He works as a CPA, so this is their busy time of the year. And he also is a tennis instructor. I can tell the court that he has some money in the bank and that his family does live here. I would ask the court, if he has no prior record, to consider RORing him on this case. If the court's not inclined to do that, I would ask that the bond be set at $1,000.
All right, Mr. Linder, does Mr. Baker have any prior history? No priors, okay. All right, now, Ms. Baker, I see that you're here with us today. Are you here just to observe this morning or to speak?
I'm here to speak.
Okay, so let me say a couple of things to you that I tell everyone who comes to first appearances, okay? Most importantly, we're only here to talk about bond and release conditions today. So I don't want to hear anything about the background or facts of the case. If you're here to say anything about that, that's to speak with the attorneys after, okay? All right, the second thing is, because we're in first appearances, everything that we say here is being recorded, and that can be used against you and potentially him at a later date. You understand?
I understand.
Okay, all right, so if you want to speak, then I'm going to ask you to speak loudly into that microphone in front of you. I'm going to swear you in first, and then we'll begin, okay?
Okay,
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
thank you. And now you can put your hand down and please just state your full name for the record.
My name is Anya Baker.
Okay, all right. And Ms. Baker, what is it that you would like to say?
I heard that there is a possible no contact going to be applied to my husband, and I would like to ask to please not do that. He is a good father, and my son is suffering right now. My son is awfully sorry about everything that happened. He feels so bad that my husband, his dad, had to spend the day and night in jail. He is waiting for him to come home desperately. He wants to apologize to him. My son has been crying for hours. And it would be very bad for my son to not see his dad. He loves him
Okay,
very much.
okay.
And he wants to apologize and he wants to talk to him. He's a good dad. He's a really good dad.
All right, thank you, Ms. Baker. Okay. Based on the information that I've received in the probable cause affidavit and the information provided today that Mr. Baker does not have any prior history, I will set the bond at $1,000, and rather than imposing a general order of no victim contact, I will impose an order of no harmful contact. Mr. Baker, I want to make sure that it's very clear that I am going to allow you to return to the residence where your son resides, but there is a no harmful contact order in effect, so I hope that you understand what that means, okay? All right, the bond is going to be set at $1,000. You understand everything, Mr. Baker?
Thank you.
All right, you're very welcome.
Your Honor, the order of no harmful contact is overstates objection.
All right, that's fine. The objection is noted. Thank
Mr.
you.
Baker, this is Mr. Miller from the Public Defender's Office. I'm going to ask you to please document your injuries. Take pictures. Yes, you document your injuries. I understand that this case is unlikely to go forward, but just in the interest of preserving your rights, please take photographs of your injuries, okay? Can you do that?
Yeah,
Thank you.
will that get my son in trouble?
No, Mr. Baker, this is just about preserving your rights. That's the only reason that he's saying that, okay? All right. It's all right. Good luck, sir. It's okay. If you have any questions about it, I would rather you speak to the attorney off the record about it, okay? All right. That's going to be it for today. Thank you. Okay.
Thank you very much.
Thank you. Good luck.
Thank you.
Okay. All right. So now we're going to start with our regular list here. Next up will be Venice Parks. Good morning, Ms. Parks. Ms. Parks, you're before the court this morning on 2 charges. Count 1 is aggravated battery causing bodily harm or disability, domestic violence. Count 2 is an immigration hold, which has a no bond hold. I find probable cause, and I will hear the parties' recommendations beginning with the state on count 1.
Your Honor, I'm requesting a $3,500 bond, no victim contact.
Your Honor, Mr. Fabarik interviewed Ms. Parks. It appears that she has been living in South Florida for about 4 years. Okay.
Judge, she has no money in the bank. I can tell the court also that they do have a little bit of money. As the mom, she lives with her mom, and her mom's going to hopefully help her to post bond today. I understand she has the immigration hold. We would just ask the bond to be set at $1,000.
How much?
I would ask for. I'm sorry. I would ask for 1,000 because she's on the no bond immigration hold.
Does Ms. Parks have any prior history?
No, Your Honor. I've never been to jail.
All right, the bond is gonna be set at $2,000. There is a no bond hold, so Ms. Parks, just so you understand, with respect to the immigration hold, since that has a no bond hold, that means that you'll go before an immigration judge in order to address that matter.
Yes, ma'am.
I also need you to understand that with respect to the aggravated battery charge, there is going to be an order of no victim contact. That
Yes,
means
ma'am.
that until further order of the court, you're not to be in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand?
Yes, ma'am.
All right. Thank you very much, Ms. Parks. Good luck to you, ma'am. Next will be Ronesia Edwards.
Good morning.
Good morning, Ms. Edwards. Ms. Edwards, you're before the court this morning on a felony violation of probation. This has a no bond hold. I find probable cause. And Ms. Edwards, since this has a no bond hold, that means that you'll go in front of your division judge so they can address how they would like to handle the matter. So they will be doing that hopefully within the next couple of days. So you'll see the division judge and then they'll address it with you, all right?
Okay, yeah, they say I see my judge tomorrow.
Okay, if that's what's scheduled, then that's what you'll see them in the afternoon, okay?
Okay.
All right, good luck to you. Next will be Brandy Moore. Good morning, Miss Moore.
Good morning.
Miss Moore, you're before the court this morning on one charge of organized fraud, obtaining property greater than $50,000 by fraud. I find probable cause, and I do see that the bond is presently set at $25,000. Is the state seeking anything in addition to that?
No, she has a DOC hold.
All right,
Yeah, because of that, Judge, we would just ask to leave the bond as is at this point.
okay, all right, then I will leave the bond as set. All right, thank you, Miss Moore. Good luck, ma'am.
Thank you.
Thank you.
Is Grace Johnson still a medical one? Okay. Next will be Jamie Figueroa. Johnson. Good morning, Mr. Figueroa.
Good morning.
Mr. Figueroa, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I'll hear recommendations beginning with the state at this time.
Good morning, Your Honor. State's asking for a $1,000 bond, no victim contact, no firearms, and no ammunition.
Judge, I would normally have no problem with that bond. But here's his circumstances. He's been a resident here for approximately 2 years. He has 5 kids. They range in age from 16 down to 2. The issue is that he's going to have money deposited into his account to post the bond. The problem is it's a joint account with his wife. He has no family members here, and there's nobody he can call to post the bond if the court imposes a no contact order with the victim. So it's not that he doesn't have the money to post bond, it's just that I don't know that he's going to be able to get out. What I would ask the court is if the court would considering RORing him to pretrial standard pretrial release.
Well, I don't understand. If he has the money, I understand it's a joint account, but why does he need to have contact with her to do that?
He doesn't have the cards or anything like that to get the money.
I see. Okay. State, does Mr. Figueroa have any priors?
No, Your Honor.
All right, I will release Mr. Figueroa and place him on standard pretrial supervision. Mr. Figueroa, a couple of important things for you to know, all right? Number one, you are going to be released today, but because you're being placed on standard pretrial supervision, you must report to pretrial supervision within 24 hours in person. The paper that the deputies just handed you has instructions on where you need to go and how to do that. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
I understand.
All right. Additionally, there will be an order of no victim contact. That means until further order of the court, you are not to be in the same place at the same time as the alleged victim. That also includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand?
I do understand. I do have a question, Your Honor.
Yes.
My identification, my wallet is in the house.
Okay.
I have nothing on me.
Okay.
When I get released, all I have is a pair of shorts.
Okay, so here's what I'm going to allow you to do, Mr. Figueroa. If you need to return to the residence to retrieve your personal belongings, then you may do so one time, but it must be with local law enforcement. That means that you are to call them and make the arrangements to coordinate with them before you go there, so that they're there when you're there. Do you understand?
I understand.
Okay, all right, thank you, sir, good luck.
If I could also, just Mr.
Yes.
Figueroa, the place that you report into is literally across the street from the jail. You'll probably get out possibly by around noontime today. So you may want to try to walk over there. That way you don't have to come back down here tomorrow. Okay, if you get out before 4 o'clock. Okay?
As far as clothes, can the state help me out with that? Like, they just arrested me with a pair of shorts.
They may be able to give you a tie. I don't know what they can do over there. I'm not sure.
They may have something at the jail they can give you on the way out. If they have it, I'm sure they'll be able to give it. All right, good luck, sir.
Thank you. Thank you.
Thank you, Judge.
Next will be Ryan Wise. All right, good morning, Mr. Wise.
Morning.
Mr. Wise, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I'll hear recommendations beginning with the state at this time.
The state's asking for $1,000 bond, no victim contact, no ammunition, and no firearms.
All right, so then I will set the bond at $1,000. Mr. Wise, there is going to be an order of no victim contact. It's very important that you understand that means until further order of the court, you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you, sir. Good luck.
Quick question, ma'am.
Yes.
Sorry, just like Mr. Figueroa that just left.
Yes.
I live with this lady. All my stuff is at the house. I just need to get my car and my wallet. So call police like you told him to do.
Yes, so I will allow you to return one time. It must be with local law enforcement, so you have to call them ahead of time to coordinate that with them, okay?
Yes, ma'am.
All right, thank you, sir.
And Mr. Wise, one other thing. I'm just looking at you on video. Is your right eye, is it swollen?
Yes.
Make sure that you take or have somebody take pictures of any injuries that you have just so we can preserve it, okay?
They did at the hospital yesterday already.
Okay, perfect. Thank you.
All right, thank you.
Okay.
Okay, next will be Ryan Cook.
Mr. Wise, just if you can have somebody take pictures, just have them take pictures, okay? That's all. That's all. Thanks.
Okay. All right, good morning, Mr. Cook.
Good morning, ma'am.
All right, Mr. Cook, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I'll hear recommendations beginning with the state at this time.
The state's asking for a $1,200 bond, no victim contact, no firearms, and no ammunition.
1,200.
All right, Mr. Farbera, go ahead.
Judge, I can tell the court that he's lived here for 36 years. He's single. He is currently not working. He says he may have $100 to post bond with. I would just ask the court if the court would consider setting somewhere between $500 to $1,000 bond.
Does Mr. Cook have any prior history?
Yes, Your Honor. 2002 possession of coke. Oh, I'll start from older. Hold on. 2017 Berg structure and a felony petty theft adjudicated. 2017 resisting without violence adjudicated. 2017 petty theft felony adjudicated and probation was revoked. 17 possession of cocaine adjudicated. 2016 unlawful use of a name adjudicated. 2015 possession of PCP adjudicated. 2015 sale of PCP and possession of PCP adjudicated. 2014 possession of cocaine adjudicated. 2014 petty theft adjudicated. 2010 resisting without violence and false identity adjudicated. 2010, possession of cocaine and resisting without violence, adjudicated. 2010, possession of cocaine, grand theft, false name, possession of drug paraphernalia, and
All right.
possession of cannabis, adjudicated.
That's fine. All right, I'm going to set the bond at $1,000. Mr. Cook, there is going to be an order of no victim contact. It's important that you understand that means until further order of the court, you are not to be in the same place at the same time as the alleged victim in this case. That also means no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you. Good luck, sir. Jarvis Harris. All right, good morning, Mr. Harris.
Good morning.
Mr. Harris, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I'll hear recommendations beginning with the state at this time.
The state's asking for $1,000 bond, no victim contact, no ammunition, no firearms.
All right. Go ahead.
Judge, I believe he can afford $1,000 bond.
All right. Okay, the bond will be set at $1,000. Mr. Harris, there's going to be an order of no victim contact. That means until further order of the court, no being in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes.
All right, thank you. Good luck, sir. Next will be Clarence King.
Hey, hon.
All right, good morning, Mr. King.
Good morning.
Okay, Mr. King, you're before the court this morning on one charge of aggravated battery, where offender knew or should have known the victim was pregnant, domestic violence. I find probable cause, and I will hear recommendations beginning with the state.
One moment, Judge.
All right.
Your Honor, the state is requesting state is requesting a $7,500 bond. This is based on the level of violence, that a child was present when this occurred and witnessed the incident, the victim's physical condition. Additionally, Mr. King's history, 2007, aggravated assault with a deadly weapon, just under 16 months state prison. He also has had 07 possession of cocaine, grand theft 03, strong arm robbery 03. Nothing further, Judge.
Judge, I can tell the court that Mr. King has lived here for 25 years, that he has one child that's 1 month old. He is a supervisor at the BB&T Center, which obviously they're shut down right now, so he's not earning any money. I would tell the court also he only has about $100 in the, thank you. He only has approximately $100 in his account. So I would ask, based on that, he has no family that can help him. There's nobody that can help him post a bond. Based on that, I would ask the court to set bond at $1,000.
Mr. Linder, you said that I believe the most recent prior you listed was 07. Is that correct?
Let me make sure there's nothing more recent. Yes, Judge.
All right, I'm willing to set the bond at $1,000, but it would be with the condition that he also be placed on standard pretrial supervision.
So are you okay? Do you want to do that? You would set the bond at $1,000. You would be able to post that based on what you told me, but you'd have to report into pretrial release. You'd have to report into them a couple times, maybe telephonically, probably one time in person, something like that. They'll go over all the rules when you go over there. Is that acceptable to you?
Yes.
Okay.
All right, so the bond is gonna be set at $1,000. If Mr. King does post that bond, he will be placed on standard pretrial supervision. Mr. King, something important for you to note, there's a couple of things, okay? Number one, your bond is set at $1,000. If you post that bond, excuse me, then you will be released. But upon your release, you'll have 24 hours to report in person to pretrial supervision. The instructions on where and how to do that are on the piece of paper the deputy's just given to you, so make sure you read that when we're done. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Additionally, as a condition of your release, there is going to be an order of no victim contact. That means until further order of the court, you are not to be in the same place at the same time as the alleged victim in this case. That order also includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that?
Understand.
All right. Thank you very much. Good luck.
Mr. King, the place that you would report is across the street from the jail. You'll probably get out this afternoon sometime. If you're out before 4, just walk across the street, get signed in. That way you don't have to come back tomorrow, okay?
All right.
All right.
All right. Good luck, sir. Next will be Lawrence John. Good morning, Mr. John.
Good morning.
Mr. John, you're before the court this morning on 5 charges. Count 1, possession of amphetamine. Count 2, possession of cannabis 20 grams or less. Count 3, introducing contraband into a detention facility. Count 4, tampering with or fabricating physical evidence. Count 5 is battery, second or subsequent offense, dating violence. I find probable cause for these charges, and I will hear recommendations beginning with the state at this time.
Your Honor, I'm requesting a $15,000 bond on count 5. This is based on the level of violence that he threatened to kill the victim and also Mr. John's criminal history. In 2013, he was convicted of aggravated battery and 5 counts of aggravated assault when he discharged a firearm multiple times at a group of people, striking one of them in the back. He was sentenced to 5 years in state prison, released in 2017.
Okay, defense?
The only thing that I can add is that he wouldn't be able to afford the amount of bond that the state's requesting. I can tell the court he's lived here for 29 years, that he works as a commercial real estate agent, that he does have some family member here and he does have some money, but he wouldn't be able to afford that. Based on what he told me, he would be able to afford, if the court were to set bond on count 5 at $1,500, he would be able to post bond. Anything more than that, though, I don't believe he's going to be able to post.
All right. Well, I'm very concerned with the allegations that have been included in the probable cause affidavit with respect to the battery charge. I believe Mr. Linder has already referenced the fact that there were threats to kill the alleged victim in this case, and there was an allegation that a firearm was discharged at the alleged victim in this case. It gives me even greater concern when I take into consideration Mr. John's prior history. I'm going to set the bond on count 5 at $10,000. I will leave the other standard bonds in place. Mr. John, with respect to the battery charge, there is going to be an order of no victim contact. That means, with respect to the alleged victim in this case, until further order of the court, you're not to be in the same place at the same time as this person. That includes no phone calls or text messages and no third-party contact or social media contact with that person. Do you understand?
Yes.
All right. Thank you. Jesus, carry on.
Medical reset, Your Honor.
All right. Ricky Ferrugia.
Good morning, Your Honor.
Good morning, Mr. Ferrugia. All right. Sir, you're before the court this morning on 2 charges. Count 1 is a misdemeanor capias related to a petty theft charge. Count 2 is a civil writ of arrest. That is not for magistrate, but so that you understand, I'm not sure if Mr. Barbaric discussed it with you, but there is an $880 purge amount, which I'm unable to modify or anything. Okay, I just need to advise you of that.
Okay.
All right, I do find probable cause, and with respect to count one, is the state able to make an offer to Mr. Ferrugia on that count?
So, Your Honor,
Okay,
offered be adjudication, time served.
all right, so Mr. Ferrugia, on the petty theft charge, if you want to resolve that this morning, the state's offer is an adjudication of guilt with time served. Do you understand that?
Yes. Can I plead no contest to that?
You can, but I'm gonna ask you a few questions before we're done, okay?
Yes, ma'am.
All right, so to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Ferrugia, do you understand everything we've discussed so far this morning?
Yes, ma'am.
All right, is anyone forcing you to resolve this case?
No, ma'am.
Okay, are you under the influence of drugs or alcohol?
No, ma'am.
Okay, do you need any more time to speak with your attorney?
No, ma'am.
All right, do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Okay, have you ever been treated for mental or emotional illness?
No, ma'am.
All right, and do you understand if you're not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I understand that, and I am a U.S. citizen.
All right, thank you. And Mr. Ferrugia, what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence as to count one will be an adjudication of guilt with time served. And once again, I'm sure you discussed this with Mr. Farberic, but that $880 purge amount will remain on count two, okay?
Now, that has to be a cash bond, correct? Cash money, not a bondsman on the purge?
Let me confirm on that one. It's a civil child support. It has to be cash, yes. Okay.
Okay.
All right?
Thank you, ma'am.
All right, good luck, sir. I'm sorry? Yes, thank you. Next will be James Franklin. Okay, so let me address something on Mr. Franklin's case, because I do see this is just an ad charge for a capias, and he's been a medical reset for the past few days. My recollection is that Mr. Franklin's counts 1 through 3 were transferred to mental health court. Is that correct? Can someone confirm for me? Right. If the other, since it's a capias, what I'm going to say is, if we can confirm the other 3 were transferred to Judge Lerner Wren, then I would be inclined just to go ahead and formally make the probable cause finding and sign the transfer order for this one as well. So he can get things done.
So, yes, the answer to the question is yes. In fact, I think this case is already transferred. No, wait, let me check. This case is already in front of Judge Lerner Wren, Judge.
Okay, all right. So then in light of the other 3 already being transferred to her as well, I'm going to make a probable cause finding in absentia, and that way when Mr. Franklin is back from medical, Judge Lerner Wren will be able to address everything with him. All right, thank you. Okay, next will be Corey Pierre. Good morning, Mr. Pierre.
Hello, how you doing?
I'm well, thank you. Mr. Pierre, you're before the court this morning on 2 charges. Count 1 is grand theft auto, and count 2 is resisting an officer obstructing without violence. I find probable cause, and I do see the standard bond on count 1 is set at $1,000. Is the state seeking anything in addition to that?
Yes, Your Honor. The state is requesting a GPS monitor. First off, I can tell you, Your Honor, I spoke to a detective from BSO's burglary, the specialized burglary unit.
Yes.
He's been advised by Dade County they are going to be dropping a warrant, hold on him, a warrant for similar like offenses at a date. Additionally, at the time of this incident, he is on conditional release for juvenile offenses, grand theft auto, and numerous violations of probation. He also has priors as a juvenile for burglary conveyance, grand theft auto, identity theft, grand theft auto, grand theft auto, grand theft, burglary conveyance, grand theft auto, burglary conveyance. Nothing further, Judge.
You're requesting a specific level for the GPS monitor?
I'm fine with level 2, Judge.
All right, let me go to the defense.
If I can just ask one question.
Go ahead.
Sir, I know you indicated to me, Mr. Pierre, that you live with your parents. Is that correct?
Yes, mother and dad.
I'm sorry?
Yes, mother and dad, both
Okay.
parents.
And you have their address in the jail, correct? You would be able to give that and furnish that to them?
Yes.
Okay. Judge, we had no objection to the $1,000 bond. He can post that, but if that's the only way he can get out, then I'm sure he would want to take it.
Okay. All right, so I'm gonna leave the $1,000 bond in place, but that will be with the condition that if the bond is posted, Mr. Pierre will be placed on pretrial supervision with a level 2 GPS monitor.
All right.
All right, thank you, sir. Good luck.
You too. Have a nice day.
Thank you. Next will be Pedrito Gonzalez. While Mr. Gonzalez is coming up, I just want to confirm the booking sheet and findings I have indicate dwelling, but I believe this is supposed to be conveyance. Is that correct?
That is correct.
All right, let me just make the correction.
Going back to room.
All right, good morning, Mr. Gonzalez.
Good morning.
Sir, you're before the court this morning on 5 charges. Each counts 1 through 5 are each a separate count of burglary of an unoccupied conveyance unarmed. I find probable cause. Is pretrial standing on this case? All right, I'll hear from pretrial before I hear from the parties.
On March 20th, in cases 202138 CF10A, 3 counts of felony petty theft, as well as 202523 CF10A, 1 count of felony petty theft, 1 count of possession of drug paraphernalia. He was released from custody on the 20th and told to report to pretrial supervision, and he failed to show up. In addition, based on the court finding of probable cause on today's arrest, we're going to ask for his pretrial status. He will vote in both of the open cases.
All right. All right, in light of the recency of the new charges and the fact that Mr. Gonzalez failed to report to pretrial in both of the prior cases as he was instructed, I am going to grant pretrial's request to revoke his pretrial services in both of those cases. I'll just read the numbers one more time for the record. Those are cases, Mr. Gonzalez, one moment. Those are cases 202523 CF10A and 202138 CF10A. Additionally, in each of those cases, I am going to place a no bond hold so that the division judge can address how he or she would like to handle Mr. Gonzalez's 2 cases.
Judge, can I say something?
Mr. Gonzalez, I don't want you to say anything about the facts of the case. Do you understand?
No, I'm not gonna say nothing about that. I haven't been on pretrial, so I don't know what.
Sir, you were placed on pretrial on March 20th. You were supposed to report to pretrial when you were released, as you were instructed, and you failed to do that.
March 20th.
Yes.
Court order, if the court wants me to.
That's all right.
Your Honor, I wasn't even in jail for I got March 20th of this year.
Yes, sir.
Sir, don't say anything. You need to talk to your attorney about it and see if they can work that out, okay?
No, because I was released ROR.
Mr. Gonzalez, ROR 2 pretrial, okay? When you're released, you have to report to pretrial. That is what you were instructed to do, and you did not do that.
No, ma'am. As far as Judge Siegel told me, he says I was released under ROR, and I needed to report to my next court date, which was going to be May 8th. That was what Judge Siegel told me. You know what I mean?
Let me
And
see
I
the
and I
order.
asked him several times, Your Honor.
Mr. Gonzalez,
I
one
said-
moment. I'm going to pull a copy of the order myself and read it to you.
I was released on the
Mr. Gonzalez,
ROR.
I'm going to look at the order myself. This order was signed by Judge Merrigan on March 20th, 2020, indicating that Mr. Pedrito Gonzalez is being released on standard pretrial release, per an agreed order between the parties.
Your Honor, just for record purposes,
Go
I
ahead.
believe Judge Siegel signed it for Judge Merrigan.
Okay.
If Judge signed it for ROR, they never told me pre-trial.
Sir, I'm going to read you exactly what it says. Agreed order for release. Attorney for defendant having presented to this court an agreed order for release, ASA Julian and the undersigned counsel agreed to Pedrito Gonzalez being released on standard pretrial release. That is what the order says.
How come they told me ROR then?
Mr. Gonzalez, you can address it with your division judge, all right? I'm not going to argue with you about it any further. I'm going to hear recommendations from the parties on the new case, please.
Based on the court's order, I'm requesting a $2,000 bond on each of these burglary conveyances. And at this point in time, until further order of the court, no return to Henderson.
Judge, I would just tell the court, he's homeless, he's not working, he has no money, so even without the no bond holds, he wouldn't be able to post any bond.
All right, so in light of the fact that Mr. Gonzalez is going to have to go in front of his division judge to address the no bond issue anyway, I'm going to set the bond on the new case at $2,000 per count. And Mr. Gonzalez, there is going to be a no return order to Henderson until further order of the court. That means that you're not to go to or return there until a judge orders otherwise. Do you understand?
Yes, ma'am.
All right, thank you, sir. Good luck.
That's crazy. They tell me
Next will be
ROR.
Bruno Da Silva.
Medical reset. Medical reset.
Oh, he's a medical reset?
Yes, ma'am.
Okay. All right, we'll reset him to tomorrow. Thank you. Next will be Michael Downey. All right, good morning, Mr. Downey. Mr. Downey, you're before the court this morning on 2 charges. Count 1 is second-degree petty theft, third or subsequent offense. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause, and in light of the no bond hold that Mr. Downey is going to have to address with the division judge, do the parties have anything to add on count 1?
No, Judge.
Okay, then I will leave that standard bond in place, and Mr. Downey, you'll be seeing your division judge soon to address that no bond hold. Good luck, sir. Next will be John Lusant. Yes.
Okay, move like a couple more chairs. So let's see.
Okay, good morning, Mr. Lusant. Sir, you're before the court this morning on 6 charges. Count 1 is first-degree arson of a dwelling or building where people are present. Counts 2, 3, 4, and 5 are each a separate count of second-degree arson. Count 6 is a felony probation violation which has a no bond hold. I find probable cause for these charges, and at this time, I will hear the parties' recommendations beginning with the state.
Your Honor, first I'm just gonna ask, when setting the bond, essentially I'm gonna ask the court to not even really take into consideration the fact that he's got a no bond hold, because I do believe Mr. Lusant poses a significant danger to the community in general, but particularly the neighborhood he lives in. So I'm asking the court, when setting bond release conditions, to proceed as though this is what the situation will be should he be eligible for release at some point. I don't know what the other state's going to end up doing on his VOP. He has a warrant out of, let me see what that's at. Let's see. Out of Fayetteville from 2016 for breaking or entering a motor vehicle, burglary. I'm sorry? I'm showing out of the state of Virginia, it looks like the case he's on probation for is an assault on a law enforcement officer. He has felony credit card larceny out of 2016. So, Your Honor, I'm going to be requesting that the court set the bond on count 1 at $25,000. On counts 2 through 5, $10,000 each. Pre-trial release with a GPS monitor, and because of the nature of these offenses, I'm asking that he not be able to come within 1,000 feet of the victims or the residents in this matter. Frankly, if that means that where he currently lives is too close, well, Your Honor, I would ask that that distance still be kept in place. No victim contact, no return. I would also be asking for a special release condition that Mr. Lusant not be in possession of any potential accelerants that could cause a fire.
I believe Mr. Lusant is already on a GPS monitor, is that correct? Is that?
He was. That's how they were able to locate him to some of the evidence in this matter.
All right.
No, that's part of his probation, or I guess it was version of community control.
All right, in light of the allegations and the information that has been provided, I am going to set the bond on count 1 at $25,000. The bond on counts 2 through 5 will be set at $10,000 each. If Mr. Lusant does become eligible for release and posts that monetary bond, he will be placed on pretrial supervision with a level 1 GPS monitor. There will be orders of no return and no victim contact. I'm going to order a 1,000-foot stay away with respect to each of those locations. And there will be a special condition that Mr. Lusant possess no weapons or accelerants until further order of the court. Mr. Lusant, it's very important that you understand that if you do become eligible for release and you post the monetary bond, you're going to be placed on the level 1 GPS monitor. Essentially, that means that you would be placed under house arrest. I need you to understand that there will be orders of no return and no victim contact. Since you're going to have the GPS monitor, that will include a 1,000-foot stay away order from each of the alleged locations that are at issue in this case. In addition to that, the no contact order means that you're not to be in the same place at the same time as any of these individuals. That also means no phone calls or text messages to them, whether you know them or not, and no third-party contact or social media contact. Do you understand what I've explained to you?
Yes, ma'am.
All right, thank you, sir. Good luck. Next will be Jordan Christoph.
It's at North Broward, Your Honor. We have an argument.
All right. Thank you. Good morning, Mr. Christoph.
Good morning.
Mr. Christoph, you're before the court this morning on 8 charges. Count 1, burglary of an occupied conveyance unarmed during a state of emergency. Count 2, burglary of an emergency vehicle unarmed during a state of emergency. Count 3, grand theft auto. Count 4, resisting an officer obstructing without violence. Count 5, aggravated fleeing with injury or damage. Count 6, leaving the scene of a crash involving damage to property. Count 7, operating without a valid driver's license. And count 8 is careless driving, but is not for magistrate. And Mr. Miller, I'll hear your arguments at this time.
Thank you, Your Honor. Mr. Linder and I spoke earlier, and I think we agreed that count 1 is superfluous. And I would further argue that there is no evidence that the state of emergency that we are currently under had any bearing on this burglary, nor is there evidence that he crossed county lines in order to commit this burglary. And so I would ask the court to find no probable cause for those 2 enhancers.
Odds to count 2, you mean?
On count 2.
Okay, Mr. Linder.
It's fine, Judge.
All right, so I will find no probable cause for count 1, which means that will be placed at an ROR. With respect to count 2, I will remove the enhancers for state of emergency and across county lines, so it will just be burglary of an emergency vehicle unarmed. And I do find probable cause as to the remaining counts. All right, and now I will hear recommendations from the parties. We'll start with the state.
Your Honor, I'm going to be requesting a $20,000 bond on 2, a $5,000 bond on 5, and a GPS monitor. 1, I'm concerned for the safety of the community and Mr. Christopher's future appearance in court, considering the lengths he went to avoid being apprehended by law enforcement, the multiple people he put in danger, and ultimately, when the first stolen vehicle he was driving, he was unable to proceed. He then went into a vehicle with emergency lights, an emergency vehicle, and essentially, and I spoke to Detective Rilla this morning, he was trying to use that vehicle to continue to flee from law enforcement. If he's willing to go to those extents to avoid apprehension, I don't know that the court can really have any confidence of him willingly appearing in court without the appropriate bond and release conditions.
Judge, I would just tell the court that he's lived here all of his life. He has 1 child that's aged 4. He's not currently working. He has no money in the bank, and he said that his family cannot help him. So any bond at this point, he probably would not be able to afford. I would ask with regards to count 2, though, that is a lot higher than the norm. I would ask for the court to set that bond at about $5,000.
And Your Honor, just briefly, he was, and I'm showing it's still pending, he was arrested 2 weeks ago for loitering and prowling in Dade, and it is a lot higher than the norm. He's not charged with just a regular burglary of a conveyance.
Does he have any other priors besides the recent arrest that you just mentioned?
That's all I see at the moment.
All right, I'm gonna set the bond on count 2 at 15,000. And as to count 5, I'll set the bond at 2,500. I'm gonna leave the other standard bonds in place, and I'm not going to impose the GPS requirement at this time. All right, thank you. Good luck, sir. Next will be Billy Hockaday. Is Mr. Hockaday at me?
Yes, ma'am.
Okay. All right. Good morning, Mr. Hockaday. Sir, you're before the court this morning on 4 charges. Count 1 is possession of alprazolam. Counts 2, 3, and 4 are each a separate count for a felony warrant for violation of pretrial. Those have no bond holds and are not for a magistrate. I find probable cause. In light of the no bond holds, do the parties wish to be heard on count 1? All right, I'll leave the standard bond in place on that. Yes, Mr. Hockaday.
Is there any way that you can give me a bond on those so I can bond out?
So, Mr. Hockaday, since those have no bond holds that were set by your division judge, I do not have the ability to lift them. That means that you'll be going before the division judge soon, so that judge can decide what they want to do with those cases. All right?
Yes, ma'am.
Good luck, sir.
Thank you.
Next will be Henry Nelson.
Hey, Your Honor, we have an argument.
Okay.
Yes, ma'am, Your Honor.
All right. Good morning, Mr. Nelson.
Good morning.
Sir, you're before the court this morning on 1 charge of battery, second or subsequent offense. And Mr. Miller, I'll hear your argument at this time.
Judge, the alleged victim in the case was unable to, essentially, unable to communicate with the police and identify this man as his alleged assailant. Apparently, this was called in as a fight. The defendant here was identified as the primary aggressor. However, there's no evidence to that effect. And the witness in the case IDs Mr. Nelson, but does not give places him at the scene, but doesn't give any details about what he did while he was there. So he identified and being placed at the scene. There's nothing to indicate. There's no evidence that he was actually involved in a fight. And even if the court assumes from the totality of the circumstances that he was, there's no evidence that he was the primary aggressor. It's conclusory. And so I'd argue that there is no probable cause at this time to hold him on this charge.
Your Honor, I would argue it's not conclusory because Mr. Miller's only mentioning one contact with the victim. But apparently there was a second opportunity where the officer had contact with the victim, and apparently he was coherent because he advised the officer that he wanted to prosecute.
Agree, Your Honor, he did. He advised he wants to prosecute, but he still doesn't identify this person as the person that he was in a fight with, and he doesn't give any details about, how the fight occurred, what happened. There's just not enough here to hold this man, Judge.
Well, respectfully, I would disagree with that due to the witness statement that was obtained. I understand that, there's more information that could have been provided, but for today's hearing purposes, I do believe that there's enough to meet the threshold for probable cause. Per the witness statement, Mr. Nelson was identified. The officer does indicate he's the primary aggressor, and based on the fact that the alleged victim in this case was incoherent and had to be transported to the hospital for treatment, and we see Mr. Nelson here today, I think that based on all of this information, it's enough for me to find probable cause in this case. So I am going to make that finding. And is pretrial standing in this case? All right, I'll hear from pretrial first.
The defendant was placed on pretrial supervision on February 27, 2020 for a charge of felon, concealed weapon, or possession or use of drug paraphernalia. Case number 19-14463 CF-10A. Based on the court's finding of probable cause for this new arrest, I'm going to ask the defendant's pretrial status be revoked at this time.
All right, I am going to grant pretrial's request to revoke pretrial services in case number 19-14463 CF-10A. Because these are felony charges, I am going to place a no bond hold so that the division judge can address the matter further with Mr. Nelson and determine how he or she would like to proceed. I do see on the new case there is a $1,000 standard bond presently set. Is the state seeking anything beyond the $1,000 bond?
I am, Your Honor, and I know I normally don't do this, and I know it may be a moot issue because of the court's order, but simply put, Mr. Nelson just has a lengthy history involving violence. You've been advised of his felony weapons offense. 2019, he was convicted of shooting at or throwing a deadly missile. 2018, battery on a law enforcement officer and resisting with violence. 2016, battery. He's had other priors, but 2013, assaulting a law enforcement officer. 2009, strong arm robbery, felony battery with prior convictions. He was sentenced to 46.5 months state prison as an habitual offender. And he has a lengthy list of priors that predate that.
So what's your recommendation?
I'm sorry, 5,000.
All right.
Judge, what I would argue is that in light of what Mr. Miller brought forth to the court, that there was no real idea of Mr. Nelson being the person that committed the crime. I would ask that he be ROR'd on this case. If the court's not inclined to do that, I would ask the court to just keep the $1,000 in place, since the court's already revoked the bond at this point, he can't get out.
Okay. All right, in light of the circumstances, including the fact that Mr. Nelson is going to have to go before his division judge to address the no bond hold, I'm going to leave the $1,000 bond in place. There will be an order of no victim contact and an abundance of caution. Mr. Nelson, I just need for you to understand that whether you know the alleged victim or not in this case, until further order of the court, the no contact order means no being in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact with that person. Do you understand that, sir?
I understand, ma'am.
All right. Thank you, sir. Good luck to you. All right. Next will be John Toomey. Is he still a medical loan?
Yes.
She said all right. She said okay, she going down. Thank you.
All right. Next will be Jermaine Arthur.
Medical reset, ma'am.
Okay.
One more.
Next will be James Larimore. And I just want to confirm while Mr. Larimore's coming up, these are change of charges, but they're supposed to be attempt. Is that correct?
Yeah, that's what I believe Your Honor found proof evident.
Yeah. I just need to make the correction on my finding sheet. All right. Good morning, Mr. Larimore.
Good morning.
Sir, you're before the court this morning on 2 change of charges. These were originally listed as attempted first-degree murder. Count 1 has been changed to attempted first-degree murder resulting in serious bodily injury while armed. Count 2 has been changed from attempted first-degree murder to attempted first-degree murder with a deadly weapon. State, is that correct?
That is correct, Judge.
All right, I do find probable cause, and I believe that Mr. Larimore has no bond holds on these. Is that correct?
That is correct.
All right. Does the defense wish to be heard?
Judge, in light of the court's finding of proof evident presumption, great, we're going to reserve any arguments for another day.
Okay. All right, then, in light of the fact that these are essentially just technical changes to the charges, I'm going to adopt my prior ruling and make a preliminary finding of proof evident presumption great and place no bond holds, or replace the no bond holds on both charges. And once again, for the record, that is without prejudice for Mr. Larimore to have the appropriate Arthur hearing before his division judge to further address that matter. All right, good luck to you, Mr. Larimore.
Thank you.
Okay. Yes.
Before we close the book
Yes.
on this morning, I'm requesting the court to appoint Public Defender's Office to represent a gentleman who has some cases that haven't been before the court.
Okay.
Timothy Coney, Coney, case number 18006-618 CF10A and 19011-642 CF10A.
All right, that's fine. I'll sign those orders.
Thank you.
That brings us to the end of our morning docket for today. We are having an afternoon docket that will begin at 1 o'clock this afternoon. I'll see everyone tomorrow. Judge Lerner Wren will be presiding this afternoon. Thank you.